Is Jacobson still good law after Jones? Guys, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another Roadside Chat. This question comes from an officer in Kern County, California. This officer asked very interesting questions, very deep questions, and I just had to tell you that I respect it. So here's another question he has. So since the Jacobson decision was made under a Katz analysis, I'm going to explain all this. Would the circumstances of the case be unconstitutional after Jones reviving trespass search? I'm having trouble understanding that how this cat out of the bag analysis is legit after Jones found that trespass is also a search. Okay, so let's kind of break this down. A lot of you are like, what the hell is this guy talking about? Well, I know what he's talking about. Let's break this down and do some fundamentals, and then I'm going to answer your question. The first thing is, let's talk about what Katz is. Katz, K-A-T-Z, is a U.S. Supreme Court case from 1967 that essentially said if a person exhibits a reasonable expectation of privacy in the area or item searched, then they have a Fourth Amendment protection in that thing searched, okay? So what happened in Katz was that the FBI put a tape recorder on top of a phone booth while Charles Katz was in the phone booth making a telephone call. He was engaged in interstate gambling. This recording device picked up his side of the conversation, and based on this one-sided conversation, they're all able to kind of put the pieces together that he was engaged in illegal gambling. Now, they go to Supreme Court. Katz is like, this is a Fourth Amendment search. The FBI is like, no, it's not. We did not enter the phone booth. You don't have any, privacy was not even the word of the day, but you don't have any protection in this phone booth. It's not your phone booth. Plus, we didn't enter it. But the Supreme Court starts saying, you know what? It's not just trespass that is an issue here. It's the privacy interest. And the Supreme Court starts using the word privacy in connection with Fourth Amendment searches. The word privacy does not exist anywhere in the Constitution, okay? And so people like Antonin Scalia, R.I.P., had problems with this. He's basically saying, guys, he wasn't around at the time in 1967. He wasn't on the Supreme Court, but he was like, you guys are making this all up. There is no right of privacy in the Constitution, right? But regardless, the Supreme Court at the time said there was, and they came up with a two-part test. First, did the person exhibit a subjective expectation of privacy? In other words, did he or she do those things that they needed to do to keep their stuff private? If you were going to put a marijuana plant on your windowsill, don't complain when the cops see it. Now, if marijuana is not illegal, let's advance it to change it to a brick of cocaine. Don't complain when the cops see it. That's the first thing. Okay, fine. Now you actually have the marijuana plant behind Venetian blinds, and the Venetian blinds are closed. The next thing is, did the cops do something that would have exceeded the society's expectation of privacy? In other words, objectively, did this violate privacy? So if the officer went up to some blinds and they were closed, and he went up to the little string hole, right, and saw the marijuana plant in plain view, that is likely going to violate a reasonable expectation of privacy. Number one, did the person put the marijuana plant behind blinds that were closed? Yes. Did the officer do something that was objectively kind of offensive to privacy? Yes. I think we can agree that if you saw a government agent looking into your window like this, you'd be like, man, why are you doing that? Looks like you were peeping Tom. Does not look like it's plain view. Now, let's fast forward to Jacobson. Jacobson is a 1984 case that what happened here was that Jacobson had a FedEx parcel that was searched by FedEx. Now, we don't care about private searches under the Fourth Amendment. They searched it because I guess through their negligence, they damaged the package. When they opened it up, they found cocaine in a cardboard tube. They then put it all back together. They called their friends at the DEA. The DEA arrived, and after they were told what was in the package, they opened it and they saw the cocaine for themselves. then they did a controlled delivery, I think, and the rest is history. The U.S. Supreme Court said that no search occurred at all. Why? Because when FedEx opened the package and they saw the cocaine, their actions, their private search eviscerated, eliminated any privacy interest that Jacobson had in the search places. Now, if there was things in the package that were unsearched, let's say there was 2 boxes in the FedEx package. One was searched, one was not. Jacobson would not lose his privacy interest in the unsearched box, but he would in the one that was searched. Okay. So no privacy interest in the search box. So when the DA opened up the box and they saw the same thing that FedEx did, that replication of what FedEx did not invade a reasonable expectation of privacy. Let's fast forward to Jones. Jones is a seminal case from 2009 that basically holds that not only is there a privacy search, right? Not only can you implicate the Fourth Amendment by invading somebody's reasonable expectation of privacy, Katz, but you can also implicate the Fourth Amendment by trespassing with the intent to gather information. What happened in Jones was that the FBI put see how it's the FBI always? FBI, you guys gotta give me a call, okay? I wanna teach you. The FBI put a GPS tracker on Jones's vehicle without a warrant. And they tracked him for about 30 days. And based on this tracking information and some other things, they got a warrant for his stash house, and they found over like 100 kilos of cocaine, $1 million in cash, and so forth. Just as a little side note, I interviewed Antoine Jones, the Jones in the U.S. Jones versus Jones, and I have about over a 2-hour interview on the Blue Gold channel on YouTube. You got to check it out. So we go deep into his case, his whole life, what happened, and so forth. It actually is a very fascinating story. So Jones held that not only privacy, but also trespass. So what this officer is asking is, hey, look, okay, I know the Supreme Court is still saying that that there was no search occurred in Jacobson because there was no privacy interest left, but aren't you still trespassing? Yes, strictly speaking, you are trespassing onto something that Jacobson has standing to contest. The problem is, and this is, by the way, this is $1 million question because I've had this question myself. However, the cases that talk about trespass still require some level of privacy, right? If you don't have any, if you have just no privacy, if there's nothing to hide, right? If the information has already been exposed, then you're still not, there's no information to seek. In other words, trespass is trespassing, which is intermeddling with the intent to seek information. I believe that if courts were to address a Jacobson-style search today, they would still find that you would still need some kind of privacy, something kind of hidden in order to still have a search. In other words, yeah, you may have a trespass, but you don't have the seeking information because what you're seeking is already known. And that's some of these cases that have been coming out. Now, again, I still think it's a very legit question. If I was a defense attorney, I would definitely argue that Jacobson is no longer good law after Jones. I just don't see the courts doing that. I don't see, because you would also, if you get rid of Jacobson, a lot of case law falls apart. A lot of cases just fall apart because cops do this type of search a lot. So regardless, though, you still have to have some kind of private information in order to have a search under the Fourth Amendment. That's what I think is happening in a nutshell, in layman's terms. I'm sure that somebody a lot smarter than me can write a journal article on really the implications here. By the way, there have been some journal articles kind of not on this exact issue, not Jacobson, but just on how Jones still requires something that's not in like, something more than just touching something. You still need that privacy interest. And so Katz is still somehow intermeddled with trespass, which makes things a tad confusing, which again, that's why I appreciate the question. But at the end of the day, I think we're still good. And we still teach that blue to gold. We don't teach that that this doctrine is dead after Jacobson. I hope this is interesting. If you have any questions about this or anything else we teach, please leave it in the comments below or contact us directly. If you like what we're doing here, like, subscribe, share with your friends. And until next time, my friends, you stay safe.